Zero for the respondent submitted that the application for habeas corpus was premised on reasonable belief that the respondent was in the custody of the police. He invited the court to take into consideration Article 10, which is the article of the Constitution that is on national values and principles of governance, Article 19, rights and fundamental freedoms, Article 20, application of Bill of Rights, Article 24, limitation of rights and fundamental freedoms. And counsel submitted that this court has jurisdiction under Section 8 of the Magistrates Court Act, which states as follows, and I quote, Section 8, subsection 1, I quote, subject to Article 165, 3B of the Constitution and the pecuniary jurisdiction to hear and determine applications for redress of a denial, violation or infringement of or threat to a right or fundamental freedom in the Bill of Rights. Subsection 2, the applications contemplated in subsection 1 shall only relate to rights guaranteed in Article 25A and 25B, 25A being freedom from torture and cruel, inhuman or degrading treatment or punishment, and 25B, freedom from slavery or servitude. Section 8.3, nothing in this act may be construed as conferring jurisdiction on a magistrate's court to hear and determine claims for compensation for loss or damage suffered in consequence of a violation, infringement, denial of a right or fundamental in the Bill of Rights. And Section 8.4, the Chief Justice shall make rules for the better exercise of jurisdiction of the Magistrates Court under this section. Dr. Gitao, in his submissions, he fully indicated that he fully associated himself with submissions of fellow counsel and indicated that the respondent's family were in distress and had sleepless nights and were extremely worried about the safety of the respondent. In his submissions, the prosecution informed the court that the purpose of the mention was to give the court an update as to the state of the investigations. He submitted that the respondent had only visited the offices of the investigating officer on only 2 occasions, and thereafter he failed to show up. He indicated that an application for habeas corpus was premature as investigations were still taking place. He further indicated that the respondent was in contempt of the orders of the court and a warrant of arrest ought to issue. In rebuttal, the counsel for the respondent indicated that the DPP should address the citizens' liberty in a more serious way, and that one Susan Wariga had recorded a complaint of a missing person via OB number 05/12/8/24 at Kikuyu Police Station. Mr. Njiru further informed the court that the DPP had not rebutted applicability of the application on the aspects of the law. Counsel for the respondent made an application for habeas corpus. The law provides under Article 51(2) of the Constitution, and I'll quote, a person who is detained or held in custody is entitled to petition for an order of habeas corpus. So what is habeas corpus? This is a Latin maxim which simply translates to, and I quote, you have the body and by extension produce the body. The Black's Law Dictionary describes it as, I quote, a writ employed to bring a person before a court, most frequently to ensure that the person's imprisonment or detention is not illegal. In simpler terms, this is regarded as a fountain of liberty. End of quote. The writ of habeas corpus is now enshrined in the Constitution as a fundamental right from which there can be no derogation as per Article 25D of the Constitution. I have taken into account the submissions made by counsel, and I believe the first issue for determination is whether this court has jurisdiction to handle this application seeking an order of habeas corpus. Jurisdiction flows from the laws, and the recipient is to apply the same with any limitations embodied therein, and such a court cannot arrogate itself jurisdiction or craft an interpretation. As earlier indicated, under Articles 25D and Article 51(2) of the Constitution, habeas corpus is a fundamental right that may not be limited. In the Magistrates Court Act, Section 8(1) provides as follows, and I'll quote, "Subject to Article 165(3)(b) of the Constitution and the pecuniary jurisdiction to hear and determine applications for redress over denial, violation or infringement of or threat to a right or fundamental freedom in the Bill of Rights." Subsection 2 provides, and I quote, "The applications contemplated in subsection 1 shall only relate to the rights guaranteed in Article 25A and B of the Constitution." The said provision, that is Section 8 of the Magistrates Court Act, that is subject to Article 165(3)(b) of the Constitution. I'll quote 165(3)(b) of the Constitution. It provides as follows: subject to Clause 5, the High Court shall have B, jurisdiction to question whether a right or fundamental freedom in the Bill of Rights has been denied, violated, infringed, or threatened. Under Article 23(1) of the Constitution, the High Court has jurisdiction in accordance with Article 165 to hear and determine applications for redress of a denial, violation, or infringement of or threat to a right or fundamental freedom in the Bill of Rights. Section 389(1) of the Criminal Procedure Code provides as follows, and I will quote, "The High Court are before the court to be dealt with according to law. B, that any person illegally or improperly detained in public or private custody within those limits be set at liberty. C, that any prisoner detained in a prison situated within those limits be brought before the court to be examined as a witness in any matter pending or to be inquired into that court. D, that any prisoner detained in a prison situated be brought before a court-martial or commissioners acting under the authority of a commission from the President for trial to be examined, touching any matter pending before the court-martial or commissioners respectively. E, that any prisoner within those limits be removed from one custody to another for purposes of trial. And F, that the body of a defendant within those limits be brought on a return of sepi corpus to a writ of attachment. Provides, and I'll quote, that the Chief Justice may make the rules of the court to regulate the procedures under this section. In the Supreme Court petition number 41 of 2018, Gitonga Mwangi Mureithi, suing as the legal representative of the estate of Mwangi Stephen Mureithi and Zerabanu Jan Mohammed Senior Counsel, the executrix of the estate of the Honorable Daniel Toritich Arap Moi and Ray Mark Limited. The Supreme Court bench of Kenya, in a bench comprising of PM Mwilu, DCJ, and Vice President of the Court, Mohammed Ibrahim, Smoky Wanjala, Njoki Ndung'u, and Isaac Lenaola, had an opportunity to address the issue of jurisdiction in matters of habeas corpus at paragraph 61 of the said judgment. I will quote: "Before the promulgation of the 2010 Constitution, the writ of habeas corpus applied in Kenya as a common law doctrine by virtue of Section 3(1)(c) of the Judicature Act, Cap 8 of the laws of Kenya. The jurisdiction to issue the writ vested, as it still does, in the High Court. It is a special and supervisory jurisdiction which empowers the court to oversee, safeguard, and uphold the liberty of a citizen in the event of an illegal incarceration. The writ of habeas corpus is now enshrined in the Constitution as a fundamental right from which there can be no derogation under Article 25D of the Constitution." End of quote. Therefore, it's in that regard that I fully associate myself with the findings of the Supreme Court of Kenya decision, and the upshot is that this court has no jurisdiction to entertain an application for habeas corpus. That is the order of the court. Dealing with that application for habeas. And since I have no jurisdiction, as I've said, I think you know the proper forum to handle that. And just for avoidance of doubt, the prosecution had sought a warrant of arrest. The warrant will not be issued. Just let me finish. So the warrant will not be issued based on the report made of a missing person at Kikuyu Police Station.
Warrant of arrest to issue. We are therefore seeking your guidance on the contempt of your own order pertaining to the bail that you issued. Yes, that is very, very important because it is left hanging in the air. And more specifically, in order to aid this honorable court, we are specifically seeking an order that your order pertaining to bail and the terms thereof be strictly adhered to by the prosecution and also by the DCI. It's just that, without even going into the issue of a habeas corpus.
Yeah, additionally, Your Honor, who is sustaining it? Why is it being sustained? And for how long shall it be sustained?
Yes, Your Honor. First, I have to apologize to the court and to my colleagues that I have not been in this matter for a long time. Two, that there is something called justice. And I would love if Your Honor, would put that on record, that justice is not a statement of the air. It's not hot air, it's not wild wind, it's not anything like that. justice means something to a human being. We are talking about a human being who is in custody, so that it is important for you to go further than the reasons of habeas corpus and the reasons given by the Supreme Court or other courts to say that your court is indeed embedded with the authority to issue that order. I request of you that
wish to have a copy of the ruling as soon as the court can facilitate. We shall be able to pay for that. And my second request is that the court directs the DCI, where the respondent has been reporting, to have a formal way of recording his reporting, because the times that he has reported there, the two officers, one is in court, I don't know where Mr. Maina is, have been away, and they have delegated that reporting to another officer, which now they come to court and say he has not reported. We need formal summons where they can be signing his attendance, or whoever they delegate to sign his attendance will actually take up that, because we feel this was an ambush to a person who is actually not present and not known where he is to defend himself and to tender evidence of his attendance. We would humbly request for those two on behalf of our client. Thank you.
a person who has come to court to seek justice needs to receive justice. So the first thing that needs to happen, we'll deal with the rest of the issues later on. It's not about going to the police to record and be recorded for. No. It should be here and how they are holding it. Thank you.
Pressing us on the fate of the misrelease application. The respondent was supposed to appear before you. He's not before you. Yes, Your Honor. We need to know why is he not before you.
The miscellaneous application that was before you, as the court has properly rendered itself on the issue of habeas corpus. Your Honor, the issue that has been raised last, that this court should address rather facilitate or ensure that the respondent is present before your court, this honorable court, Your Honor. That is an issue that rightly has been, the court has given guidance that is an issue to be taken up in the right forum, that is the constitutional court. Your Honor, besides that, the defense has raised the issue of the conditions to be adhered to by the prosecution and the investigators that were issued by this court. We wish to submit that, Your Honor, the orders of the court were that it was a conditional release of the respondent to be reporting to the investigators to facilitate investigation. And that is why, Your Honor, you are coming to court yesterday. So, Your Honor, the prosecution did not, there were no conditions set on the prosecution to adhere to, Your Honor, as far as these investigations are concerned. And for that reason, Your Honor, I would very humbly submit that to that end, we have no obligation to the investigation, to the investigators and to these investigations. And secondly, my learned senior, Mr. Ndegwa, submitted that rather sought the indulgence of the court to give direction on who sustains the miscellaneous application. Like I've said before, Your Honor, these investigations were pegged on the cooperation of the respondent upon his conditional release. Your Honor, we were before you on the 12th of July. This matter came up for mention yesterday on the 15th of July. That is a month apart. One of the conditions was that the respondent was supposed to report twice a week to the investigator to facilitate the investigations. However, the IO who was present yesterday indicated to the prosecution that the respondent has only attended to them twice in a space of 1 month. So Your Honor, it is a humble submission which Your Honor maybe should go on record that the respondent has only attended to the investigators twice.
We cannot accept that.
Your Honor, I think that needs to go on record by way of an affidavit by whoever it is that will make that claim. My colleague cannot say this off the bar. Yeah, thank you.
And Your Honor, for records, if you remember my submissions yesterday, I said that I indicated to this court specifically that our client has religiously, I used the word religiously, has religiously been attending to those sessions, Your Honor. And every time that he would attend, he would inform me. Personally, he would inform me. So I can tell you even from the bar that he has been attending.
Even that needs to go on record.
Yes, indeed, that
by
is
way
also
of affidavit.
Indeed.
Even that needs to go by way of affidavit.
The miscellaneous, rather the investigations, Your Honor, rather the miscellaneous application is premised on the cooperation of the respondent. So Your Honor, if the respondent, then we can only, we cannot, Your Honor, I think and indicate that the prosecution, just like the family, is looking forward to the conclusion of the investigations of the missing person report, so that this investigation can be complete, as well as the family, the respondent can go back to his family. That will be all, Your Honor. Thank you.
And has in the investigations. He's no longer with the bank. They have abducted him and put him in communicado. He is not connected with the bank in whatsoever manner. This is a white-collar crime if it ever happened for whatever reason. How was he supposed to assist in their investigation? And subsequently, does it mean that they do not appreciate the right of our clients not to incriminate himself in whatsoever manner? So we are making an application, Your Honor, that the miscellaneous applications be closed. It cannot be put into motion into perpetual and to infinity. We are making an application that the same be closed. And then we move on to the substantives of the case.
Our client, being the respondent, that is David Mashiri Kimani, is being held presently as we are speaking at Capitol Hill Police Station. Let me finish. Let me finish.
He's on his feet.
Let me finish. We cannot be on the 2 feet. That is basic courtesy. He is being held at...
Yona was objecting to counsel's submission because Yona knew the right thing for counsel to do is do a proper application to court.
You cannot dictate to me how I'm supposed to address the court. Let me finish, Your Honor. That is the first thing. And secondly, I've just been informed that last night, the police were with him in their Land Cruiser at the Thika Greens estate.
Your Honor, I still stand on my objection. Your Honor, counsel is introduced.
The issue he's raising is what we could do is one or two things. Either the court directs the OCS of Capitol Hill Police Station to bring the subject here, or in the second, the court decides to adjourn and we go to Capitol Hill and see who is there. And that is all we need to do.
Yes, Your Honor.
Because it is important that this court is seen to do justice to everybody. It is not just enough to say that we have to make a formal application. A formal application is a good thing, but it's also a foolish thing. And I don't intend to insult my colleague. When I say foolish, it is actually nothing. When you are doing a formal application, you just write, and then you sign, and then you file it, and then that's all. There is nothing else. So I am requesting Your Honor, either you direct, we can come back in a few minutes. It's now 10:12. We can come back about 1 hour after now. Then we either come here or we go to Capitol Hill. It's just walking distance from here. We can walk.
Directions on the issue of the court reviewing its ruling. This court is now functioned as official on the application for habeas corpus. On the issue of contempt of court, parties are at liberty to file a formal application. On the matter raised from the bar, I believe the same ought to be raised in a formal way so that the court can render its decision based on the evidence tendered before it. And since the respondent is not present in court, the miscellaneous file will still remain open until further orders are issued. In the event of any new development, parties may move the court in the appropriate way. And finally, a copy of the typed ruling will be supplied to all the parties. So I'll give you a mention, but if there are new developments, you can move the court in the appropriate way. Counsel, that one will guide you. Can agree on a date? Yes, I've also indicated a copy of the typed ruling will be supplied to all the parties.
Can you give us Monday?
Monday?
Yes, Monday.
Mention? Just agree on a date. Just agree on a date, kindly. Just agree on a date. Just agree amongst yourselves. You don't have to involve me.
That's why